Chief Justice, and may it please the court. My name is Helen Laurie, and I represent the petitioner, Mr. Christopher Hildebrandt. At this time, I'd like to reserve 3 minutes for rebuttal. Mr. Hildebrandt, who was the defendant below, is asking this court to reverse the decision of the 12th Circuit Court of Appeals and apply the unambiguous text in 2305.11a. This court should reverse this decision for 3 reasons. First, and most importantly, 2305.11a is unambiguous and should be treated as such. The General Assembly demonstrated the general meaning of accrual through both action and inaction. Second, the nature of the relationship between the parties and the nature of the injury in defamation cases is distinguishable from other claims this court has applied the discovery rule to. Third, the discovery rule in defamation cases would create a plaintiff-friendly policy where defendants could be liable because they couldn't get enough reliable evidence to support their truth defense. On my first point, and this is the most important point, the 2305.11a is unambiguous, and this case should be decided on this point alone. The General Assembly has intentionally modified its 6 uses of the word accrual in similar statutes to explicitly provide for a statutory discovery rule. In addition, the general definition of accrual at the time that 2305.11a was enacted was the time that a suit could be maintained. This court confirmed that general definition many times, most recently in 2018 in LGR Realty Incorporated. The court said that the statute of limitations commences to run as soon as the injurious act complained of is perpetrated.
Counsel, isn't there another legitimate line of cases in Ohio where the court has adopted accrual as a judicially defined term that led to the discovery rule in a variety of contexts?
Your Honor, I would argue that that Ostreicher and the similar line of cases that began the application of the discovery rule for medical malpractice and other bodily injury claims is limited to a bodily injury context, and when the injury is manifested after the point of the alleged bad act. Defamation doesn't fall under either of these categories. Well,
but what's the word of the statute for medical malpractice statute of limitations? Is it accrue?
It is accrue.
And
it's in a different division, and then Ostreicher interpreted that division and limited the application of the discovery rule to a bodily injury context because it was otherwise the result would just be so unconscionable that this court couldn't permit this case to or wait for the legislator to decide what accrue meant.
But when I look at the facts in your case, there's an allegation of this set of facts being unconscionable, not to give
Yes, Your Honor. One can argue that this result is unconscionable. However, I don't believe that this defamation injury can really reach the bar of unconscionability. What led this court to apply the discovery rule in the past is when justice just can't demand that we dismiss a bodily injury case when someone has been so deeply wronged and hurt.
And so you're saying that could never happen in a defamation case?
You're
saying it didn't happen in this case?
It did not happen in this case.
Well, but so the meaning of accrue, I wouldn't think would turn on the nature of the specific injury. In this case, it would be more about what's the nature of the injury generally under what you're talking about here, right?
Can you repeat that, please?
Sure. I mean, so just because the injury in your view wasn't sufficiently severe here to give rise to a claim of unconscionability, what if in the next defamation case the injury is sufficiently severe to give rise to definition of unconscionability? It's hard for me to believe that whether or not there's a discovery rule turns on the nature of the specific injury in a specific case.
Your Honor, if this court was to adopt a discovery rule on these facts, it would be really difficult to really define the line on what is discoverable and what is not. Because of the nature of the publication was through email or text, it is unlike other instances that other states have applied the discovery rule to defamation, and it just creates tedious factual inquiries down the line. And this another case could come and might come.
Tedious factual inquiries, that's like the legal system, right? I mean, that's the job, is tedious factual inquiries.
Otherwise, law school wouldn't take 3 years.
Yes, Your Honor. However, this is just a simple procedural matter. It should be quickly dealt with and moved on to the merits of the case. And otherwise, it would just increase.
But you don't want to move on. I mean.
Yes, Your Honor. Not in this case. I don't want to move on. But
right, you don't want to move on to the merits of the case. In fact, you want this quick little procedural issue to be the end of the case, right?
Yes, Your Honor. But if it was to be adopted, it would increase transaction costs for future defendants and plaintiffs and decrease access to justice for those.
Well, that sounds like a great argument for the legislature, but certainly the question of what accrues means for us, you wouldn't think would turn on transaction costs. Right?
Your Honor, as I was saying about the text, the legislator has recognized a general definition, and the general definition of accrue at the time that the statute was enacted was the time a suit could be maintained. That definition has been consistently applied over 100 years in Ohio.
Well, can you maintain a suit before you know you've been injured?
Right, so do you agree? Would it be unconscionable for the statute of limitations to begin running before a plaintiff knows if they've been damaged?
In some cases, in the cases such as bodily injury, medical malpractice, that this court has applied the discovery rule to, yes, it would be. However, in this case, this is a defamation injury where the plaintiff clearly can't point to loss of revenue, loss of job, any sort of criminal investigation by the auditor.
Well, in this case, but maybe in another case, then, Ted.
Yes, Your Honor, there would be another case. This is just not the correct
So
case.
there's the discovery rule sometimes. It just depends on whether or not the injury is sufficiently severe.
In this case, Your Honor, I would like you to decline to extend the discovery rule on these facts. This is not the correct factual background to apply the discovery rule to.
Well, what about the 6th District case back in the 1980s that interestingly had 2 judges who later become justices of the Supreme Court, where the guy lost his job as, I believe, the police chief up in Northwest Ohio, and his family had to move, and they applied the discovery rule to a defamation case. I mean, does it take those kinds of facts before you can apply?
Your Honor, I'm not sure if I'm familiar with that case. Is that either DePillo or Raisin?
That's the
Razor.
pillow.
Right.
Wood County.
So I would just say that DePillo is unreported and it hasn't been cited extensively by any other cases. And I believe that citing cases is what gives them precedential value. And this case just it shouldn't have undue consideration in this case.
Well, what about all the 12 other states that the Court of Appeals in this case cited? And I didn't list them all, but there's fairly substantial jurisdictions there.
Yes, Your Honor.
They have the discovery rule, don't they?
Yes, Your Honor, but case law from other states doesn't really need to be followed here. The decisions in other courts reflect their own state history and customs. And I couldn't personally locate a case where a state Supreme Court adopted the discovery rule for defamation where the publication was through private communication, like email or text. Adopting the discovery rule in these facts leads all Ohio courts into years of tedious line drawing and again, increased transaction costs and decreases access to justice. And also the time that the courts were applying the discovery rule of defamation and the popular time has passed. Like the recent decisions from this court have been less amenable to applying an exception to the statute of limitations. So I'd also like to point this court to 2 other cases from other states as well. Sorry, I'd like to talk about policy. So I would say that truth is an affirmative defense that a defendant must prove in this case. And this court has recognized that bribery is one of the most difficult claims to prove due to the usual lack of evidence. There isn't a paper trail usually because people are trying to cover up their acts and the eyewitness memories tend to fade over time. A defendant would then be forced to defend a defamation claim regardless of how many years or decades have passed. They would probably struggle and fail.
Only until the person discovered it, right?
Correct, Your Honor, but when let's say in this situation, if the discovery rule is adopted for defamation, there is no statute of repose in the statute that limits liability absolutely. So if anyone could say a statement about somebody and they could be facing liability for that decades down the line, and it could be true, but they still have to hire a lawyer and litigate the claim and make their truth defense proven.
Right, but I'm just saying I don't know, that's only if the person doesn't discover it, right? So presumably some bad consequence follows, and there may be something that puts a person on inquiry notice, for example, and that inquiry notice could start the clock running.
Right.
I'm just not sure that the parade of horribles is necessarily quite so horrible as you suggest.
Right. Well, I would also argue that there's a statute of repose from the General Assembly that has limited liability for medical malpractice and legal malpractice claims, which both this court and the General Assembly have applied the discovery rule to and want to create that kind of dynamic. And there just isn't that dynamic in the statute that would limit liability. And also, I would argue that
one of the answers that if you had this court construe accrued to allow the discovery rule for defamation, the legislature could always come back and put a statute of repose on, as they did with medical malpractice cases. So it isn't the parade of horribles necessarily. The legislature wants to fix this thing.
Yes, Your Honor. But again, I would revert to my first point that this should be decided on the unambiguous text alone. There is a modification. There's only one modification in statute of the word accrue was when the legislator applies the discovery rule. And because of this court has been using the general definition of accrue over hundreds of years. They face compelling arguments to the contrary. Most courts, except for the 12th district in this case, has never deviated from this definition.
And accrue means what?
It says that it commences to run as soon as the injurious act complained of is perpetrated.
Injurious act complained of. So doesn't that suggest the person knows they've been injured? Or at least knows of the act?
Yes, Your Honor, it suggests that, but however, the appeals courts haven't construed it that way. There is many examples of all the appeals courts in Ohio that just consistently construe it the same way, even when the publication is secretive or otherwise unknowable. And this 12th district in this case is the first case to depart from that and try and apply the discovery rule.
Well, the 6th district did 30 years ago.
Right.
You got two court appeals districts going this way.
Right, but I believe that was the unreported case. And I just
Still a decision. I mean, it's
right, Your Honor. But I would also want to bring back to the inquiry notice point. I also believe that Weidman potentially could have been on inquiry notice because he suspected serious deception at play in a conversation with Roberts, and he expressed a desire.
Is this presented and ruled on below or not?
I'm not sure, Your Honor. I don't think so. But there was a conversation between him and Roberts that he suggested that he wanted to learn the entire landscape of the communication that has been leading up to this point. And there just is no evidence in this case yet that there was any follow-up on that suspicion. And so, from that point, he still had time to litigate his claim under the statute of limitations in 2305.
that's a separate issue. If the court adopted discovery, then the trial judge could have a hearing about what the facts are in this specific case as to whether or not Weidman was on notice, couldn't it?
They could, Your Honor, but I would argue that this case is not inherently unknowable because it was through an email communication, or text communication, and other cases that apply the discovery rule have been through paywall protection, employee records, tenure reports, and other confidential things. Can I briefly conclude? In conclusion, it's premature to adopt the discovery rules to defamation cases on these facts. There might be a future case where common sense points to the adoption of the rule, but it is not this case. For now, the court should reverse the decision of the 12th Circuit and hold that the discovery rule does not apply to any defamation claim. Thank you.
Chief Justice, and may it please the court, my name is Kevin Glomsky, and I represent the appellee, Mr. Weidman. This court should affirm the 12th District's well-reasoned decision applying the discovery rule to toll the statute of limitations on claims for libel that was published in a secretive, concealed, or otherwise inherently unknowable way. 3 reasons support this conclusion. First, despite what opposing counsel argues, the statute of limitations in RC 2305.11a is ambiguous. Second, while the statute of limitations is ambiguous, the legislative intent behind that statute is unmistakably clear. The General Assembly never meant to prevent people like Mr. Weidman from bringing their causes of action. And third, applying the discovery rule in circumstances like those presented in this case is consistent with both state and federal courts across this country. I'll begin by talking about the statute. And I think your honors were right to point out that accrued is undefined and it provides no clarity on when a cause of action comes into existence. So all questions of statutory interpretation begin with the text. Our operative word is accrued, and with no statutory definition, this court often looks to dictionary definitions to understand the common ordinary understanding of a term. And Black's law defines accrue as to come into existence as an enforceable claim or right. Unfortunately, that adds no clarity to the statute. Different claims in our state come into existence at different times. So for example, a breach of contract cause of action comes into existence at breach irrespective of knowledge, and the statute is clear on that point. By contrast, exposure to toxic chemicals and bodily injury resulting from exposure to toxic chemicals comes into existence at the moment of discovery, and that's unmistakably clear from the statute. So without more language in 2305.11a, it's hard to determine at what point this cause of action comes into existence. And this court has set.
Counsel, if that's true, why don't we leave it to the legislature to fix this? Because now we've got 2 court of appeals that go one way, 6 or so that go the other way. And lawyers are arguing to the Supreme Court about what the statute means. There's a long history in the state of deferring to the legislature to fix things that they've written. Why isn't that the proper resolution here?
Well, Your Honor, this court has said in Turner v. Hooks that when good arguments support competing interpretations of a statute, you should turn to the legislative intent. And the General Assembly has actually provided this court with a framework for interpreting its ambiguous language. In section 1.49 of the Ohio Revised Code, 1.49e says this court should consider the consequences that would flow from its interpretation of an ambiguous statute. And I think the consequences are clear, and they were highlighted while opposing counsel was presenting their argument. The obvious and most flagrant consequence that would result from not applying the discovery rule is that my client, Mr. Weidman, would have been forced to bring his cause of action against his unknown cause of action against an unknown defendant in 2011 to preserve any right to recovery in the future. And this court has said in Ostriger that that's an unconscionable result. And I know there was some discussion earlier about whether or not the harm bears on that. I think what matters is the undiscoverable nature of the harm. For one, defamation can be horrible, especially for someone like a public servant like Mr. Weidman. If he's defamed, it can ruin his livelihood. But two, the fact of the matter is that the injury was undiscoverable, and this court has consistently said when an injury is undiscoverable and becomes discoverable and remains right for remedy, the rule applies.
But that's been in the context of bodily injury mostly.
Your Honor, it's been applied for legal malpractice. It's been applied for wrongful death. It's been applied for.
The statutes supported.
When the discovery rule was applied, they did not. It was the court extending the discovery rule from a judicial interpretation of the statute of limitations. And the second and other critical consequence that would flow from not adopting the discovery rule here today is that it would essentially create a liability loophole. As long as a wrongdoer like Mr. Hildebrandt is able to conceal his wrongdoing for the period or the statute of limitations period, he avoids civil liability. So you can imagine situations, and in fact, they're not too different from the facts of this case, where someone publishes a defamatory statement to perhaps a group of friends, waits the period of limitations, and then publishes it to a wider audience. And at that point, he's accomplished his goal of defaming someone.
And each new publication would be a new court in that setting, wouldn't it?
And Your Honor, and it doesn't require multiple publications. You can also imagine situations where there's a single publication and eventually more people arrive at that publication.
Well, that wasn't what you just posited.
Right.
So under the one you just posited, there won't be a statute.
Sure, it raises the publication rules, but I think the point remains that the same consequence can occur with a single publication, and that more people can arrive, and in fact, the injury can get worse over time. And again, the wrongdoer is able to accomplish their goal of defaming someone and completely avoid civil liability. In this court,
that endemic in the law. I mean, there's a statute of repose for various kinds of torts. There's loopholes in the tax law. If they don't catch you with the IRS within so many years, you absent flagrant fraud, you're home free. I mean, that's the nature of the line drawing in the law, isn't it?
Your Honor, and I think the purpose of a statute of limitations, and we don't dispute this point, is to prevent people from sleeping on their rights. But I think there's a critical distinction here. My client has not been sleeping on his rights. He simply did not have the information necessary to file a coherent cause of action.
I don't know that it's only about sleeping on rights, though, right? It's also about concerns that witnesses may lose their memories, that the quality of evidence may not be the same 7 years later as it was today, or 2 years later, whatever. I think it's more than just sleeping on rights.
Sure, Your Honor, but with something like a defamatory statement, I don't think those concerns are should concern this court so much. And I would just note that as recently as September, the Sixth Circuit, and obviously this is persuasive authority, but I think it's important. The Sixth Circuit said in Snyder Hill versus Ohio State that the critical piece of information is that when information asymmetries exist between the wrongdoer and the claimant, that warrants application of the discovery rule. And I think that's very clear in this case. Mr. Hildebrandt clearly controlled the information necessary for my client to file a coherent cause of
What do we
action.
do with all the cases that have said that the liable cause of action accrues upon publication? Just overrule
Your Honor, I think going back to, I'm assuming you're referring to Pearl v. Coke, that wasn't a Supreme Court of Ohio case. And so to the extent that you're weighing competing precedent, I would say that the precedent where the Supreme Court of Ohio has applied the discovery rule in the same circumstances as those exist today, which is an undiscoverable injury that becomes discoverable and at the point of discoverability remains right for remedy, that should be more instructive of how the court should rule today in applying the discovery rule in these circumstances for libel. And that actually gets me back to my second point, which is section 1.49D, when this court is interpreting ambiguous statutory language, the General Assembly has authorized this court to look at its precedent in understanding legislative intent. And again, I would say that this court's precedent is clear. When there's an undiscoverable injury that becomes discoverable and remains ripe for remedy, the court should extend the discovery rule. This goes back to Ostricker. In that case, it was exposure to asbestos. That's obviously a latent illness. He didn't discover his illness related to asbestos until much later. The court said it would be unconscionable to bar his right to recovery simply because he didn't know about his injury, and they told the statute of limitations there. It's not exclusive to medical injuries, though. I referenced Collins v. Soka, which had to do with wrongful death. There, the discovery rule was extended to toll the statute of limitations on a wrongful death cause of action until the survivors of a decedent were aware of a criminal conviction of the wrongdoer in that cause of
What about
action.
Rowan?
Excuse me,
Rowan versus Schaefer?
Your Honor, if you mind reminding me of the facts of that case.
Apparently there, the defendant made disparaging remarks about the plaintiff, causing the plaintiff to be shunned by his religious community.
Your Honor, I think that the discovery rule in the context of libel and defamation remains an open question, and it's a logical extension of the application of the discovery rule to other torts and wrongful acts in Ohio. I don't think there's any way to distinguish the undiscoverable nature of this injury. And so I think to the extent that this court would be overruling precedent, it would be overruling all of the cases where the discovery rule has been applied in the past, because I just don't think it can be distinguished with regard to defamation into something like wrongful death or legal malpractice or even medical malpractice.
Does that open the floodgates for, I didn't know I had to breach a contract, or I didn't know that some other kind of legal harm was suffered, and therefore the statute of limitations everywhere suddenly becomes a universal discovery?
No, Your Honor, because I think in a lot of different contexts, the legislature has been more clear. So specifically for the breach of contract, they took pains to define accrue, and they said accrual happens at the moment of breach, irrespective of whether the injured party has knowledge of the breach. So there you have the specific statutory language that's plain text that clearly forbids application of the discovery rule. So to the extent that my opponent argues that the court would be legislating from the bench here by applying the discovery rule, in fact, the court would also be inserting language into this statute if it expressly excluded the discovery rule, because the legislature did not define accrual more specifically to preclude.
I guess I'm wondering, to the extent a rule exists in case law, and you don't like the rule in case law, if the rule in case law with regard to defamation cases is accrual upon publication, and you don't like that rule, isn't the right spot to change that rule in the General Assembly? In other words, somebody needs to say what the rule is, but this is just a statutory rule. The General Assembly can change it tomorrow. We see, and they know how to change it. If they don't like precedent, they can change it, but they haven't changed it, right?
Sure, Your Honor, I would first say to the fact that the General Assembly has changed other statute of limitations in the past, I don't think that this court can tell the General Assembly that they should legislate in broad strokes. There are any number of reasons why a legislature might amend one statute of limitations and not another. We can't make anything from those actions or inactions. What we have here today is an ambiguous statute, and you have the tools and the authorization of the General Assembly to use those tools of statutory interpretation to interpret this statute to include the discovery rule. And Your Honor, I would also point out as another point that the discovery rule applies in both federal and state courts across this country. So I mentioned Snyder Hill versus Ohio State. That was a very recent federal court case in the Sixth Circuit. And there, the court said that in all situations where there is this lack of information required to file a coherent cause of action, then the court should default to allowing the discovery rule. And then state courts across this country have specifically applied the discovery rule to instances of defamation. Our neighbor, West Virginia, in the case of Padden v. Sears, applied the discovery rule to defamation. In that case, it had to do with a woman who sent a check in to pay off her account at Sears. That check was returned for not being backed by sufficient funds, and they filed a criminal bad check complaint against her. She had already sent in a good check, so she filed a defamation action saying Sears had defamed her by filing this criminal bad check complaint. She had no idea within the statutory period that that bad check complaint had been filed, and she didn't realize that she had been defamed until she had actually been arrested. And the court in West Virginia emphasized the fact that it would be, again, unconscionable to bar someone from their right to recovery if they didn't have the requisite information to file a coherent cause of action. I think that's important. Again, you have to imagine the fact that Mr. Weidman in 2011 would have been required to file an unknown cause of action against an unknown individual in order to preserve any right to recovery. And I think that gets to the essence of the point. It's hard to imagine that the General Assembly intended for the statute of limitations to operate in this way. Your Honor, I'd like to address the fact that some questions that were addressed to opposing counsel on the workability of this standard. I think this is an exceptionally workable standard because it exists in other contexts. The discovery rule by definition operates so that the cause of action in these particular set of circumstances begins to run at the moment of discovery or when a cause of action becomes discoverable. So I don't think this runs the risk, as opposing counsel argues, of creating indefinite liability because in fact the rule is self-limiting.
Aren't there difficult proof instances where you've got a defamation that's so secret or so obscure, and how does the defendant come in and realistically prove, well, you should have learned about this last year, not this last month? I mean, aren't those, because of the nature of the defamation that's postulated, very hard to prove.
Your Honor, in those set of circumstances, if it's so concealed, in that hypothetical, does the plaintiff even know that the cause of action has existed? Because
well, that's the point. You've got to have a hearing about that. And aren't these cases that are going to be hard for a trial judge to sort out? One will say, no, I didn't know about it until such and such a time. And the other will say, well, look at all these other indicia that you knew about it. I mean, those are difficult hearings.
Your Honor, I would just point out the fact that in discovery rule cases, this court has said by its very nature, the rule must be specially tailored to the particular context in which it applied. And this court engages in line drawing all the time. So there will be questions that arise from application of the discovery rule. But the fact of the matter, and with respect to this case, that'll happen on remand. What I think is important is
just leave it to the trial judge and we don't have to worry about it.
You're right. I think it's case dependent and context dependent, and mindful. May I have 30 seconds to conclude? I think there are questions that will need to be answered, but this is a workable standard. It's a reasonableness standard, and reasonable standards exist in law in all different areas of the law. And so I would conclude by asking this court to affirm the 12th District's well-reasoned decision adopting the discovery rule in these narrow set of circumstances. I thank the court.
Thank you.
Your Honor, may it please the court. I'd like to make 3 points on rebuttal. My first point is the legislator did speak loud and clear in this case, and there is no need to engage in statutory interpretation. 2305.11a is unambiguous because the use of the word accrual wasn't modified like the other uses of the statutory discovery rule, which the legislator has demonstrated that it knows how to do.
Well, but it's used language in both ways, hasn't it? Or is it only one way? Is it both adopted a discovery rule and in other cases adopted a non-discovery rule?
The situation that I know that they have slightly modified it a different way is limited to that division and that division only.
So they've always, when they've added a discovery rule, they've done it expressly
for that
My
division.
understanding from your colleague was that in a breach of contract case, there is no discovery rule, and that's also expressed in the statute. Is that not accurate?
I'm not sure, Your Honor. I'll have to file a supplemental brief. So the legislature did not clarify the language in 2305.11a because there was nothing to clarify. Accrual had a set meaning in statute, and reported Ohio cases have been consistently following it until the 12th Circuit reversed the trial court in this case. The legislators also presumed to know all prior judicial decisions when they are acting or not acting. So the legislature has followed the judiciary in many discovery rule cases, but this is only in those cases where they have where the result, if this court did not apply the discovery rule, would be unconscionable all the time, like medical malpractice. Like it's like refusing someone a medical malpractice or legal malpractice claim because they put their trust in an expert who deceived them, and only because of that, and then like that's an unconscionable result. And people face
You don't
terminal.
think it's unconscionable to lose a viable cause of action simply because you didn't know you'd been injured by the other party?
Your Honor, an outcome has to be more than simply undesirable to be unconscionable. When you're facing terminal cancer, or you're losing a family member due to negligence, or being permanently disabled as a result of malpractice without any legal recourse, that's unconscionable. And losing
Well, not all medical malpractice leads to death. So you're saying if it's a relatively minor medical malpractice case that only led to.
Your Honor, I would argue that the category of medical malpractice cases are almost always going to be more serious than defamation injury, where defamation injury can vary wildly in levels of seriousness. And if we want to apply make the statute of limitations exception that's backed up by public policy, by statute, and by precedent, then we should apply it to unconscionable results. And because medical malpractice claims look similar, like consistently, it's always, it's a doctor, it's lock of information, but defamation is wildly diverse in types of publication and what happens, how many people know about it. And like this, it doesn't make sense to apply a blanket rule and blanket exception to save plaintiff's claim when the balance is currently correctly struck in justice between the two parties in the rule. Thank you.
Thank you to our first round, Helen Laurie and Kevin Glomsky. We're gonna move on to the second round with Joe Batchelor as the petitioner and Daniela Milan as the respondent. And whenever you're ready.
Chief Justice, and may it please the court. My name is Joe Batchelor, and I represent appellant Christopher Hildebrandt. I would like to reserve 3 minutes for rebuttal. As this court recently reiterated in State v. Bortree, because the General Assembly is the final arbiter of public policy, judicial policy preferences may not be used to override valid legislative enactments. Mr. Hildebrandt respectfully asks the court to reverse the 12th District's decision that created a discovery rule for libel claims arising under RC 2305.11a for 3 reasons. First, the plain and ordinary meaning of accrue, as it was understood at the time the statute was enacted, leads to only one conclusion. The cause of action for libel accrues at the moment the material is first published to a third party. Second, the General Assembly did not intend for a discovery rule to fit within the meaning of accrue. And last, there are several policy consequences that caution against judicially creating a discovery rule for libel claims. Now first, RC 2305.11a states that an action for libel shall be commenced within 1 year after the cause of action accrues. And the General Assembly did not define the word accrue. However, per RC 1.42, when the General Assembly has left terms undefined, courts are instructed to interpret them according to their ordinary understanding, otherwise known as the plain and ordinary meaning.
But wasn't it to construe the word accrue that some of the court's prior decisions adopted a discovery rule, as in Ostriker?
Yes, Your Honor. So as this court has instructed in Vols, to determine plain and ordinary meaning, the most appropriate way to do so is to refer to how the word was understood when the statute was originally enacted. Now, although the statute for libel was originally enacted in 1890, the language used by the General Assembly at that point in time was almost identical to the language used at this point in time, and in both cases, accrue was left undefined. However, according to various legal scholars, including former Justice Scalia, reliable legal dictionaries in and around that time indicate that accrue is meant to be defined as coming into existence as a right or demand, or in other words, when all of the elements to a cause of action are met. Now, as applied to libel
In
claims,
1990, the word accrue could have meant that, but in 1912 or 14 or whatever the discovery rule was first adopted for medical malpractice cases, the state Supreme Court didn't say, oh, we're bound by that definition from 20 years ago. They went ahead and adopted it judicially as a different way to analyze the word accrue. So why doesn't that same open logic apply here?
yes, Your Honor. So this court's discovery rule line of cases, which kicked off in 1983 with Ostricker, and then Oliver, which is the medical malpractice case you were referring to, came about approximately 2 years later in 1985. And in those cases, the courts did not engage in any textual analysis whatsoever. They acknowledged that accrue was left undefined, and then in Ostricker, they created a rule that said that courts are allowed to interpret when a cause of action accrues. However, in that case, there was no precedent for that in Ohio at the time. They pulled that from a Maryland Supreme Court case, the Maryland Supreme Court case pulled that rule from a law review article. Rather, this court over the last 20 years has created a much more consistent way to interpret statutes where the court starts with the text, moves on to the General Assembly's intent, and then and only then moves
Well,
on
the
to
General
public
Assembly
policy.
had 40 years under that account. If they didn't like what the court said, no Stricker about accrues, they could have made it clear. They made it clear in other statutes, right?
Yes, Your Honor. The General Assembly chose to leave accrue undefined. However, it is instructed that the General Assembly created discovery rules in asbestos claims, medical malpractice, and even legal malpractice separate from that accrual language. So the General Assembly in all
Didn't
three.
they do that after judicial decisions that adopted the discovery rule? Didn't they come back and clean it up in the General Assembly afterwards?
Yes, Your Honor. So in the first case of Stricker, the asbestos discovery rule had actually already been implemented by the General Assembly before the case. However, the General Assembly did not make the discovery rule in that case. They did not make the rule retroactive. So the court took it upon itself to do so. And in all three of those cases, Your Honor, the court again engaged in absolutely no textual analysis. They just acknowledged that the word was undefined and then moved on to the
Is
policy
there a
reasoning.
potential due process issue that people are losing their claim before they even know they have it?
Your Honor, I'm not sure I have a good answer to that question at the moment. However, there may be several policy reasons that some may want to create a discovery rule for libel claims. And Trustee Weidman undoubtedly believes that there are many reasons that they should do so for him in this case. However, as the United States Supreme Court stated in Rotisky, the length of a limitations period really reflects a value judgment between the benefit of allowing the prosecution of current claims versus the benefit of preventing the prosecution of stale claims. And the Supreme Court in that case emphasized that because it was Congress that had to make that decision in the value judgment, and they should not question the General Assembly's judgment. And in this case, the court should follow the same logic in letting the General Assembly make any changes that they
Yeah, I
would
guess
like.
I'm more wondering, I mean, are there any due process overtones generally, like, let's say the General Assembly says 1 day statute of limitations? I mean, there is the open courts provision under the Ohio Constitution that says the courts of Ohio shall be open to those who have suffered injury for redress. Can the limitations period be so short that it actually impacts your ability to seek redress for your injury?
Your Honor, because of the General Assembly's legislation over the last more than 100 years, likely almost close to the state's founding, the General Assembly has not stepped anywhere close to that line, and I don't think that line is relevant to this case before us right now.
Why isn't it's Article 1, Section 16 of the Constitution that my colleague just referred to that says all courts shall be open and every person shall have a remedy by due course of law? Why shouldn't as an appellate court, this court construe the word accrue favorably to the plaintiff so that they have a court that's open and the opportunity for a remedy, as opposed to just saying, no, we're going to cut it off?
Your Honor, can you please repeat that question? I just want to make sure I'm understanding
The
you.
state constitution says all courts shall be open and every person shall have a remedy by due course of law. That's the Constitution. Now we have to construe a statute and whether the word accrue allows the discovery rule. Why shouldn't we err on the side of open courts and err on the side of a remedy for this plaintiff who says that he was defending?
Yes, Your Honor. So in this case, the plaintiff did have 1 full year to execute his claim. He wasn't limited to 1 day or even 1 month. He had the year. The law is clear on this issue, and the court has interpreted the law that way over the last century or so. But again, with the General Assembly's intent, there may be policy reasons why some might want to extend a discovery rule in this case. However, as this court has stated in Bernardini, And as the United States Supreme Court stated in Rotisky, it is a fundamental rule of interpretation that courts are not to add provisions to a statute that were not already included by the legislature. And the court in Rotisky specifically said that it's especially inappropriate to do so when the legislature has demonstrated that they have the ability to do so on their own. And in this case, the General Assembly has created several discovery rules for asbestos claims prior to Ostricker, and then in medical malpractice and legal malpractice claims. However, rather than just following the Supreme Court's decision in the state, following those cases to create a discovery rule, the General Assembly created its own version of the rule, where in both cases for legal malpractice and medical malpractice, there's a discovery rule upwards to there's a hard ceiling of 4 years, and they cannot cross.
Well, so there you go. So we'll just announce a discovery rule and the General Assembly can fine tune it.
Yes, Your Honor, but in this case, it would be in terms of the separation of powers for Ohio's bench, and also with the consequences of returning to the time of what the court did in the 1980s of relying on primarily on public policy to interpret statutes rather than consistent rules of interpretation, could also throw Ohio's lower appellate courts and trials courts into disarray in figuring out how they are supposed to engage in statutory interpretation for both discovery rule cases and any interpretation
How is
case.
this guy supposed to bring a lawsuit?
Yes, Your Honor. So in this case, Trustee Weidman, he alleged no damage from the 2011 action. So we would be willing to say that his cause of action accrued whenever he experienced actual damage, which would have occurred on January 25th, 2020. Now, in his brief, Trustee Weidman alleges that there was damage throughout the community, but he also somehow didn't know about it at the same time. And in this case, by creating that question of what is a reasonable time of discovery, but also determining what is inherently unknowable in today's world of modern technology, where we are now accustomed to Twitter and TikTok, and determining that question of whenever, for example, in a Twitter post, whether an account with no followers, but it's a public account, tweets out a defamatory statement, is that inherently undiscoverable? Or rather, would it take 50 followers, 100 followers, 1 million followers for the court to draw that line? And these are difficult questions. And rather than letting the courts do it case by case, often moving slower than the pace of technology, leaving it to the General Assembly to engage in that analysis with allowing all stakeholders involved to come in with constituents and legislators and experts in the field to really make that decision
I
would
guess
be
my
more
question is
appropriate.
more practical. If he truly didn't know about it, when was he going to file this suit within a 1 year period?
Yes, Your Honor. So Trustee Weidman did find out about the specific email within the statutory period. In fact, it was upwards of 4 months before his cause of action would have been barred by the statute of limitations. However, Trustee Weidman chose to file his lawsuit on February 17th rather than before January 25th, which is when the statute of limitations time barred his claim going forward.
But that really goes to whether he wins as opposed to whether a class of people who have been defamed but don't know it ought to have some key to the courthouse.
Yes, Your Honor. So with that question, I would like to take you back to the plain meaning. So the key is when all the elements of the cause of action are present. But in this case specifically, or in this group of cases for libel, the key is when the actual damage occurs. So using this case's facts as an example, Trustee Weidman, although the events surrounding this case started in 2011 with the email, Trustee Weidman did not allege any actual damage from that email. And as the United States Supreme Court stated in Gertz, the state's interest in compensating private individuals for libel claims only extends so far as to when there's any actual damage. However, in this case, Trustee Weidman certainly, according to his complaint, experienced actual damage as of January 25th, 2020.
So let's go back to your Twitter analogy that you just mentioned. When is there damage?
Yes, ma'am. So to prevent bad actors potentially, because there could be some concerns that an individual would try to get around the rules of this by publishing something to one person and then waiting until the statute of limitations had passed and then moving on to then make it public and try to truly hurt the plaintiff's or try to truly hurt a plaintiff's reputation moving forward. However, adhering to the plain meaning of the rule, whenever all of the elements are present, specifically whenever actual damage is present, would prevent that such thing from happening. Because, for example, Your Honor, I could not send a tweet to you regarding Judge Cole, knowing that we're going to keep it private until the statute of limitations would then pass. Rather, it would be whenever the actual damage occurred, which would be to the public knowledge of trying to damage the reputation in that case. And Your Honors, in this case, the damage in this case is also inherently different than the damage in the cases where the court has applied the discovery rule in the past, specifically for asbestos. So in those claims, the court recognized, again, with the actual damage that I've discussed before, the actual damage in the asbestos exposure, although they were exposed at one point, did not happen until upwards of 3 decades later. So that would be when the cause of action begins to accrue. And Your Honors, may I have a brief second to conclude? And with that in mind, and with the underlying principle that the General Assembly has demonstrated it can make this decision, it would be much more appropriate for the court to leave it to the General Assembly going forward. Thank you.
Chief Justice, and may it please the court, my name is Daniela Milan, and I represent appellee Thomas Weidman. This case is about the changes to publication since the defamation statute was enacted into law, and the unfairness that occurs each time a defamation plaintiff is time barred from bringing a claim when a defamatory statement was published in a secretive or unknowable manner. Appellee Weidman respectfully asks this court to affirm the 12th District Court of Appeals decision for 3 primary reasons. First, while opposing counsel claims that this court is unable to interpret the statute to apply the discovery rule, the interpretation that we ask for today is not a novel or new interpretation. This court has applied the discovery rule to this very statute in other causes of action. Second, policy considerations, including the latent nature of injury in these cases, and other tort causes of action where the Ohio Supreme Court has adopted the discovery rule, are also present here. These compelling policy reasons ask this court to act today. And third, sister jurisdictions' application of the discovery rule show that this is a workable rule in this context. There are reasonable constraints that can be placed on the rule to make sure that plaintiffs are not bringing claims that are far too stale. In the 1980s, the Ohio Supreme Court first acted to adopt the discovery rule in an asbestos tort injury claim, where the court read the word arose to allow for application of the discovery rule in order to avoid an unconscionable result that a plaintiff would be time barred before they were aware of a cause of action. In this case as well, when we look at the statute, the word accrued is ambiguous. While opposing counsel mentions that there was no textual interpretation in the Ostricker line of cases that stem from the 1980s forward, that is plainly incorrect, as each court through this line of decisions has mentioned that the statute was ambiguous on its face because of the lack of legislative definition of the word accrued or arose. That ambiguity is further referenced by the fact that there are multiple reasonable interpretations of the word accrued or of this statute in this context.
Can you clarify a factual matter for me? I understood your colleague to suggest that your client learned of this 4 months before the 1-year limitation period expired. Is that accurate? So he had 4 months even under the standard 1 year for publication approach to which to file an action?
No, Your Honor, there was some factual disputes on the record, and if you look to pages 44 through 50, I believe, on the record, you will see that there's still a factual issue regarding when Weidman was on notice of the defamatory information. I would argue that he did bring within 1 year of the discovery of the defamatory statements.
Right, but my question was, did he learn within 1 year of the publication, and did he learn with sufficient time left to bring his cause of action within a 1 year from time of publication period?
No, Your Honor, the original publication was in 2011, and that was a private email that was shared with just 2 other individuals. And so there was no time for Weidman to bring the claim within that 1 year period of time after the 2011 initial publication. If you look at the decisions across Ohio appellate courts, they follow that first publication rule, which means that the statute would start to run at that moment of publication. However, this court has never adopted the first publication rule, and this court has never heard this claim or looked to apply the discovery rule to a defamation context. And the appellate decisions across the state of Ohio all rest on weak precedent and weak foundation. Pearl v. Koch, which was decided in 1894, was a decision made before our modern standards of justice in Ohio and the modern court system in Ohio was formed. That provides a compelling reason for this court today to look at this and look at the application of the discovery rule in our other cases that stem from the 1980s forward.
Just because it's old, why is it a bad precedent? I mean, we start with the proposition the Constitution has things like free speech, and it was written in the 18th century. So just because it's an 1894 case, why is that?
Yes, Your Honor, I understand that not all old decisions would lead to weak precedent, but in this instance in particular, we're looking at the Superior Court of Cincinnati, which no longer exists, through a decision that was made before our modern court system in Ohio was formed.
It's not a common police court.
Yes, Your Honor, but this court has never heard this decision, this court, which is the highest state court in Ohio. And for these reasons, if you look at the appellate decisions, they've all applied the Pearl v. Koch precedent as a matter of copy and paste precedent. There's been no real analysis on this point. Every appellate decision has just blanket applied. If you look at Kenow and Rainey, they both automatically tell us that there is no discovery rule for defamation, but those courts never analyze the actual cause of action of defamation or why the discovery rule might actually apply in these instances. If you consider, for
The General
instance,
Assembly certainly had a chance to weigh in since 1894, right?
yes, Your Honor, the General Assembly could have weighed in on this instance, but there are many factors that move through publication, and there's changes that have been made to publication since that defamation statute was first enacted into law. For instance, if you consider the internet age and the online world, there are so many different ways now that defendants could possibly hide their identity online, for instance. If we look at Collins v. Satka, this court recognized that the inability to recognize and name a defendant in and of itself is a compelling policy reason to toll a statute of limitations. If you consider the internet now.
So wait. So the discovery rule you're asking us to adopt isn't just about discovery of the defamatory statement, but also the identity of the speaker of the defamatory statement. Is that right? So that would, under your rule, what would trigger the start of the 1-year period? When you know the statement's been made, when you know who made it, when you know to whom it was made, what do you need to know to trigger the?
Or you were damaged?
Yes, Your Honor, what you would need to know is that you were defamed so that the information itself was published. You would not necessarily need to name a defendant. You could name an unknown Jane Doe.
The Twitter example was an unknown author, but under your view, the unknown author wouldn't stop the statute of limitations from running.
Yes, Your Honor, in that instance, that's a policy consideration, and I'm illustrating that because of the Collins decision and the use of the discovery rule in that context in order for a plaintiff to be able to name the defendant. It's just one of many policy considerations.
But you're comfortable with the rule that allows a cause of action to expire because you don't know who made the statement, but you're not comfortable with the rule that allows a cause of action to expire if the statement's not known.
Not necessarily, Your Honor. It would depend on the rules of this court and the ability to bring a claim with an unknown defendant. There are states that will allow an unknown defendant to be named, and I am not fully aware at this moment of whether or not that would be applicable in this
So
court
if
of
you
law.
could do a John Doe lawsuit, you're all right with it, but otherwise you'd be making the same argument about discovery that you're making with regard to the statement itself.
Yes, Your Honor. It is a legal absurdity to ask a plaintiff to create a lawsuit and file a claim with an unknown defendant if they're not able to bring that claim to any court of law in the state. That would be barring a plaintiff entirely from having their legal day in court.
But given all of these ambiguities that you just reviewed with Judge Cole, why isn't that something the legislature ought to sit down and write a statute and say when it accrues, who has to know, who has to, so why not leave this to the legislature?
Yes, Your Honor. I understand the indication and the want to leave this to the legislature. But at this point, we have the facts in front of us. We have the compelling policy reasons, and we have the text. We've seen that text be applied in multiple ways. That shows us right away that this text is ambiguous. There's a way for us to interpret it in a way that takes into account the multiple constructions and consequences of our interpretation and reading of the statute. The General Assembly and the inaction.
You're not asking us to actually draft the statute and deal with all the other types of ambiguity that could arise. You only want us to decide your case, I assume.
Yes, Your Honor.
But then we run into the problem I think that my colleague was just asking about, which is the legislature can deal with all kinds of things in the statute, but we're going to have to piecemeal it as cases arise. And isn't that going to be?
Did John know who said it and all of those things?
No, Your Honor, not necessarily. And the reason why the General Assembly is not the only body that would be well equipped to answer this question and to apply the discovery rule, we can't read so much into legislative inaction and legislative intent. And Barry v. Branner, the Supreme Court of Oregon, told us that, and the Ohio Supreme Court and Oliver adopted that recognition that there is not this weight to be given to legislative inaction. We've seen that this court has the authority to adopt the discovery rule. We've seen that in Osterger. We saw that for this very statute of limitations, the same language, 2305 11A, in both medical and legal malpractice cases. And that alone illustrates the ability and authority of this very court to make this decision today. And if the legislature wants to act after the fact.
There's can we, but there's also should we, right? I mean, those are two different questions. I don't doubt we have the authority to interpret the word accrues. I guess I'm just wondering, should we?
Yes, Your Honor, if you move past the interpretation point, so if for argument's sake, we are saying that the statute is ambiguous, and I'd argue that it is. Yobi v. Cleveland tells us, the 8th District Court of Appeals of Ohio tells us that if there are two reasonable interpretations of a statute, there is ambiguity. If we move on from that point and we look at the other textual interpretations and policy considerations in play here, you start to see that the same type of injury that occurs in medical malpractice, in legal malpractice, and in these other areas where this court has adopted the discovery rule are present here. There is a latent nature of the injury in a defamation cause of action when defamatory information was published in a secretive manner. If you consider, for instance, the medical malpractice common scenario that everyone goes to is that the sponge was left inside of a patient's body, for example. That sponge, that inciting incident occurs at a moment when the plaintiff is wholly unable to be aware of its existence or their cause of action's existence. It's only later that the plaintiff is made aware of their ability to bring a cause of action to a court of law and that the injury fully manifests itself to that plaintiff. In this context, if you consider publication of something private, a false credit report, defamatory information over email, something published on social media, that inciting incident occurs, but our plaintiff has no ability to find that incident and to have his day in court. It is only later, when there's later circulation of the defamatory information, or when the plaintiff becomes aware of the defamatory information, that that plaintiff discovers and is fully harmed by its discovery.
What if the plaintiff says, yeah, I knew about it, I just didn't know it was actionable?
Your Honor, those kinds of decisions are decisions that our lower courts are well equipped to make. If you look at other tort causes of action, other places where the discovery rule does apply, our lower courts make those line drawing decisions every day and determine whether or not a plaintiff was time barred.
Well, right, but should a plaintiff be able to say, yeah, I knew about the statement. I honestly just didn't know that that would qualify as defamation under Ohio law, so I didn't know that I should bring a suit. I learned that a year and a day after I knew about the statement, and now I don't have a cause of action.
No, Your Honor, that's not necessarily applicable to this exact fact pattern. And when pulling it away and when looking at defamation in general, that's an instance where the plaintiff would be time barred. If they knew of a defamatory information and they had discovered it, and within 1 year they did not bring the claim, they would be time barred from bringing suit.
Why? If they honestly didn't know that that was an actionable thing, why are you so quick to kick them out of court?
Yes, Your Honor, that's a policy that would be applicable across the board with Ohio causes of action. If a plaintiff is aware and is sleeping on their rights, it's their duty to bring that claim to a court of law. And if they've continued to let that right go, those are some policy reasons that the statute of limitations is in place in the first place.
So it's different if they don't know the law than if they don't know the fact of the publication.
Yes, Your Honor, that's an entirely different scenario. So if they're unaware of the injury, they're unable to bring claim. And that's what we see in medical malpractice and legal malpractice and asbestos injury. If they're aware of the claim and they simply decide not to bring the claim, that's a plaintiff that hasn't done their due diligence and has slept on their right to bring it to court.
So isn't what you're proposing opening up a whole area in these cases where the courts are frequently going to have to litigate whether the plaintiff was aware of the defamation? Is that what you're doing?
No, Your Honor, not necessarily. And as I mentioned, there are these other causes of action where we apply the discovery rule, and there are line drawing questions that our lower courts handle day in and day out. And I believe that our courts are very well equipped to deal with these questions. If you look, for example, at a false light invasion of privacy claim, which the Ohio Supreme Court recently, within the last decade, adopted, the question of publication there is something that needs to be determined by a court, and our trial courts handle that. And so in this instance, if this court does adopt the discovery rule, which we ask for today, our trial courts would start to set that state precedent that would then come down every year with every passing lawsuit.
I assume your rule is going to be no or should have known, though, right?
Yes, Your Honor. The discovery rule in this context would mean that a plaintiff would bring a claim within a year of which they had known, like discovered itself, or they should have discovered the defamatory information.
And what test would you like us to write for should have discovered?
By it's a reasonable standard. So somebody should have discovered reasonably. For instance, if there is obvious harm to the plaintiff and within the community, there are signals, coworkers are not sitting with you at lunch anymore, your neighbors are passing you by, no one wants to talk to you. These kinds of things where there's an obvious injury, would be a different circumstance than something where the defamatory information was only spread to such a small group of people that that information itself had no way to injure the plaintiff. And if we consider the actual nature of defamatory harm, the Supreme Court of the United States in Gertz tells us that there is not only reputational harm that occurs from defamation, there's also this emotional damage and harm that a plaintiff feels. And in many ways, that harm does not fall onto a plaintiff until the plaintiff themselves have discovered the harm. And so there is this reasonability requirement that the discovery rule would allow a plaintiff to bring the claim within the bounds of reason and when they should have discovered. And this reasonability rule is, again, something that our lower courts have seen and something that other areas of law adopt as well. There are
Do
sister.
you want our court to adopt the restriction the Court of Appeals used, that the defamatory statement was secretive, concealed, or otherwise inherently unknowable? I mean, that's a bit more than just knew or reasonably should have known. That's a different kind of standard. Is that what you're asking for?
Yes, Your Honor, and I see that my time has expired. May I answer your question and briefly conclude?
Sure.
Thank you. That is the standard that we asked for today, and there are many reasons for it. It's a workable standard. It has been adopted by our sister jurisdictions. There are 18 states that currently adopt that rule in that specific context that show that we are not giving some kind of windfall to our plaintiffs. There's still a constraint on it. For instance, if something was published in the mass media, the plaintiff should have been aware of that publication. If we look at Texas and Illinois, both states have adopted the discovery rule in this context within this reasonable bounds for something near 50 years that shows its workability on its face. For these tools of statutory interpretation that we can use when looking at an ambiguous statute, for compelling policy reasons, and for the workability of this doctrine that our sister jurisdictions have shown us, I ask this court today to affirm the 12th District Court of Appeals decision to apply the discovery rule in defamation cases. Thank you.
Thank you. Thanks, Nancy.
Your Honors, I have two brief points for rebuttal. First, opposing counsel mentioned that from their perspective, the damages in libel claims are very similar to the damages in both asbestos claims and also medical malpractice. And opposing counsel specifically used a sponge example. However, Your Honor, that's just not true. In the medical literature, it has been found that when a sponge is left inside of a patient, originally it is just a sponge. But at some point down the line, whenever actual damage occurs, in that case, that would be when the cause of action occurs in medical malpractice. Applying that same principle that adheres to the plain meaning discussed in the original argument to this case, the damage in libel claims happens immediately when that material is shared with the third party. Now, in addition, Your Honor, opposing counsel brought up the case of Pearl v. Koch. And although that case was decided prior to Ohio's current judicial structure as it is since present day and was also decided more than 100 years ago, the court's underlying principle in that case is still very much in fashion today. And in that case, the court acknowledged that any exception to the general meaning of accrue would have to be applied by the legislature. And as this court has recognized recently, and as well as the Supreme Court, the United States Supreme Court, it is inappropriate for a court to add provisions to a statute that the legislature has not already included. In this court, specifically in cases of statutory interpretation, and two recent decisions acknowledged that there might have been really bad that the court explicitly disagreed with the policy decided upon by the General Assembly in both Bordry and Taylor.
But don't courts routinely, I mean, throughout history and across court systems, look at equitable considerations in deciding, for example, tolling? So there's a whole doctrine called equitable tolling, right? Where if a defendant has taken steps with the intent of hiding the existence of the cause of action, courts sometimes say, well, as a matter of equity, we're going to extend the statute of limitations period. Isn't that all that's going on here? I mean, if we're talking about secretive, like steps have been taken to prevent this from getting out more broadly.
Yes, Your Honor. However, Ohio's courts over the last 20 years have created, rather than there may be policy concerns as this court has recognized in two recent cases. However, the doctrine that the court has adopted over the last 20 years, starting with the text and then moving to the General Assembly's intent to give effect to that intent, and then and only then moving on to policy, should continue to be applied in this case. And as I was saying, Your Honor, both Bordry and Taylor, the court explicitly told the General Assembly through the case that they disagreed with the policy. However, the court acknowledged at the end of the opinion that they were constrained by the text of the statute and the General Assembly's intent They encouraged the General Assembly to change their decision. However, they left it for the General Assembly to make that decision on their own. And Your Honor, that's the underlying principle that Mr. Hildebrandt would like this court to adopt in this case by reversing the 12th District's decision to rule that a cause of action for libel accrues at the moment the material is first shared with a third party. Thank you.